Hi everyone, Dave Sugden of Evidence at Trial. Let's talk about foundation. Specifically when we're talking about witness testimony and the requirement of establishing personal knowledge. It's a seemingly super simple topic, but at trial, a lot of lawyers can get tripped up. So let's fix that now. Let's use a super simple hypothetical to illustrate the challenges and the fixes. We have a hypothetical case where all we have to establish is that a witness at the time of the accident saw that the light was green. The witness is called. The witness talks about what he or she does for a living, establishing credibility. The witness is placed at the intersection where the accident happened. And then the lawyer says, and what color was the traffic light? Objection, lacks foundation, sustained. And you're the examining attorney and you think, what have I done wrong and what do I need to do? And what does lack of foundation even mean? In this context, what it means is you as the examining attorney have not established that this witness has personal knowledge about the subject matter of the testimony. Where are these rules found? In California, we're looking at Section 702. In the federal rules, we're looking at Federal Rule of Evidence 602. And what they both say is that before a witness can testify on a certain subject, you have to establish the person has personal knowledge. Going back to our simple hypothetical, even though we've placed the witness at the scene, the intersection when the accident happens, what we haven't established is whether or not the witness was looking at the traffic light. In other words, the crash may have happened and someone may have told this witness, oh, did you see the light was red? And if this witness wasn't looking himself or herself, that knowledge is based on hearsay, not personal knowledge. This is our witness. How do we now establish personal knowledge without asking leading questions, running into additional challenges? Here's the fix. On an issue to establish personal knowledge, you'll ask the simple threshold question. Witness, do you know the color of the light at the time of the accident? The person will say yes. The next question is, how do you know that? And the witness will say, I was looking at the light, I was behind the car. Whatever the witness will say to establish personal knowledge, your next question is, what color was the light? Super simple. And so when it comes to lack of foundation, do you know something? The person says yes. Then how do you know it? This can also be a very helpful weapon in depositions because so often witnesses will testify as to things they believe to be true, and yet they may not have a foundation for it. And so a good formula in depositions is, do you know something? Yes, I do. How do you know it? And you can therefore look for potential traps in cross-examination where there isn't an adequate foundation. That is foundation in a nutshell. I hope this was helpful. This is essentially the rule. If you want to learn more about the tactics and strategies, I encourage you to go to the online course page at evidenceattrial.com and see our on-demand courses. If you like this video, please rate, review, subscribe at our YouTube channel. Thanks for watching.